Good afternoon. Welcome to the 2019 Midwinter Business Meeting Legal Update at the Desmond Hotel, formerly known as the Desmond Hotel and Conference Center, but now it's the Desmond Hotel. We have a 90-minute presentation in store for you today. For those of you who need to get CE, please make sure you get your CE card before we start. And turn it in when you leave. Don't forget to turn it back in to the individuals at the door. If you don't turn it in, we can't do anything for you after the fact, okay? But 1.5 hours of CE. Okay, so we have a lot of topics to cover today. They're very brief topics for the most part, except one's for the first time today, my associate attorney, Liz Salone, is going to be presenting a portion of the legal update. So please, everyone, be nice to Liz. It's her first time presenting. She's going to be talking about paying for reviews, likes, and ratings. That comes in the middle of the presentation. So prior to that, we have a couple other topics to talk about. So without further ado, please hold all questions until the end of the relevant section. Questions will not be answered as I go. We have individuals in the back with microphones that will come to you, and then you can speak to them through the microphone, or speak to me through the microphone so that we have it recorded for the purposes of video playback. New salesperson licensee audits. So why is there an audit going on? Well, right now the Department of State is auditing randomly individuals applying for the salesperson's license the first time. These audits are ongoing and they are numerous because the Department of State was made aware that you had individuals applying for their salesperson's license who were not completing the required 75-hour coursework prior to going in and taking the test with the Department of State. Since the department has no way to verify that against their records, they were issuing licenses to those individuals who filled out the application and passed the state test. So these individuals were either not attending the salesperson's course at all, they were going to the course but not completing all required coursework, or they were going to the course but not completing the minimum hours required in order to meet the qualifications to be a salesperson. How is the audit happening? Well, the DOS contacts new licensees randomly. They ask for proof of completion of coursework, which all of us know, being licensees, you get something to prove that you were there, or you can get something to prove that you were there. If the individual provides that to DOS and they're happy with what they get, the audit's over because the person did qualify to get that license. If they don't provide the proof, DOS follows up and asks again very nicely, please provide us with proof of the fact that you attended the 75-hour salesperson's course and successfully completed all the coursework. If they don't get a response the second time around, they then initiate a hearing before an administrative law judge, which is where the administrative decisions come from that DOS publishes. In the ALJ decisions, they're cutting and pasting the complaint section as far as what the individuals are doing. So the complaint alleges that the respondent real estate salesperson has failed to provide proof that he or she completed the 75 hours of qualifying education prior to applying for the license, and that the application contained a material misstatement that they failed to cooperate with the Department of State, because normally they don't respond if they don't have the proof that they were there. They just put their head in the sand and hope that DOS will stop, and they don't. In the first 6 months of 2018, there were 32 different decisions from the administrative law judge addressing this issue. There were only 13 other complaints that were addressed by ALJ. So out of the 45 DOS opinions that were done in the first 6 months of 2018, 32 were because of salespersons not taking the 75 hours they were supposed to take, and they all lost their license. So this is an issue, right? This is something that's happening more and more. And what the department was told was that there's chatter going on amongst individuals who want to get a salesperson's license, that you can just go and get it without taking the requisite coursework, and that's what these individuals were doing. So as a broker, are you liable if the Department of State gives someone a license, then you associate them with your firm? And presumptively the answer is no. Why? Because you can rely upon the Department of State knowing that the person took the coursework they're supposed to take before the DOS issued them a license. So as a broker, you can't be liable for bringing someone on who didn't complete their coursework if DOS gave them a license anyway. You would only be liable if you knew or should have known that the individual didn't do the required coursework prior to taking the state test. Brokers, if you are concerned about this, there are ways you can protect yourself so that you don't have the potential liability. Also, just so everyone knows, you'll get a copy of this presentation after we're done. It'll be posted at NYSAR.com as well, so you don't have to take notes or copy things down if you don't want to. So what's the best practice for brokers as far as this is concerned? Well, you want to avoid potential issues with consumers, right? It's really not a good PR thing if they find out that you're hiring people that didn't really take the course they were supposed to take. It doesn't make you look good as a broker. Fraudulent licensees are not educated as far as the practices are concerned. They didn't go to school. They didn't do their 75 hours. They don't know about agency. They don't know about different things. And they could then expose you to liability, which could in turn harm your reputation as a broker. So what can a broker do? You can ask the new licensee for proof. Say, I want to see proof, the same proof DOS would get, that you took this course and passed it. And that's how brokers can verify it for themselves if they're afraid of having someone come in who may not have taken the class or may not have completed the requisite for the class. Any questions about that?
Where would they get the proof from? Or how did they provide it?
The school, wherever they took it. Okay, it's just an issue. I can tell you that the majority of the opinions from 2018 had to deal with this. Not just the first 6 months. I have copies the second 6 months, but I didn't count them yet. But they also, a great number of them are because of this issue. Fred, then Lori. Do we have to give back the commissions earned? No, because as a broker, you didn't know the person didn't take the salesperson's course. They were issued a license by DOS. Right, but if you knew or should have known, Fred, then you would.
If their license is removed, are they entitled to get it back when they take the 75, or is this untrustworthy and they can't get license?
Lori asked, when they take their license away, are they entitled to go and take it again to get it? The Department of State has been lenient with these individuals to let them go back and get it. They weren't suspending them, so to speak, because they were claiming ignorance, which I don't think DOS wanted to get into it too much with them. So,
why isn't the DOS being more careful when giving out licenses and verifying that people took the 75-hour course in the first place, rather than doing all of the work later to audit them and take licenses away? Wouldn't it make more sense to be more comprehensive when handing out licenses?
I can't speak for the department, but my guess is it's a manpower issue. I mean, that's my, they can't do everybody. Now, the Department of State has discussed numerous times in the past that the next time they go to update e-access, they're going to make it so that when you take classes, the schools automatically send it electronically to DOS and they can verify. They don't have that yet. And they may not get it, but they want to get it. But I don't know about with budget shortfalls and stuff if that's going to come to fruition anytime soon. But they have been asking about it. So,
Anthony, is there any cluster area of people that are doing this?
it's difficult to say that only because of the unbalanced population of downstate versus upstate. I mean, percentage-wise, more people are downstate, so you're going to have a greater number downstate. But from what I've read, a lot of it's downstate. Behind you, Barbara. Look.
Oh. When they submit their application for the first time to get licensed, wouldn't it be a no-brainer for them to for the DOS to require that they also send the copy of the completion of the course with it? There's no like big managerial issue there. You get it with it, or you don't get the license. I mean, that seems simple, or what am I missing?
I can't speak for the department or their process in filing and doing applications. I don't know how they do it.
I mean, instead of like in next time e-access, we do, just send it in with the application.
Okay, next topic. New smoke detector law. So back in 2015, there was a law passed that was effective January 1st, 2017, dealing with new smoke detectors and type of smoke detectors. However, in February 2016, that law was amended to make the effective date April 1st, 2019, which is coming upon us very quickly. So the new smoke detector law, and I'm going to just paraphrase this, it prohibits the sale or transfer of smoke detectors with removable batteries. So the old 9-volt smoke detectors, you can no longer purchase them unless the vendor has them in their stock. The new ones have to be 10-year sealed batteries. And literally after 10 years, you throw the smoke detector away because, well, they're only good for about 10 years. So the battery lifespan is also the lifespan of the sensors within the smoke detector. So back in 2017, when we did NYSAR News notifying you of this new law, we pointed out the fact that although the law requires these new 10-year sealed smoke detectors, it does not apply to the transfer of real property, does not apply to leases being entered into. It only applies if you're replacing the smoke detector. Okay, so when you're selling a property and they sign the smoke detector affidavit, they can sign it so long as they're not going to replace one of the smoke detectors with one of the older smoke detectors, right? So this does not apply to transfer of real property. Many media outlets have been giving misinformation to the public about this law, saying that it does apply to transfers. It does not. Okay? So again, the law does not, I put that in caps just so you could see it does not apply to the transfer of property. And I put down stream of commerce type of transactions. We're most familiar with like Home Depot, Lowe's, Walmart, Amazon, those vendors that have them. If they have the smoke detectors in stock, they're allowed to continue selling them until they run out. But they can't order or put any new ones up for sale unless they're the 10-year sealed battery ones. Okay? This is the last section of the law, and the provisions of the section shall not apply to solely battery-operated detecting alarm devices powered by a replaceable removable battery, 9 volts, right, of owners, managing agents. That's us, right? We're managing agents as far as leases are concerned. We are agents of the owner as far as that's concerned. It doesn't apply to us as far as the transfer of real property is concerned. Now, obviously, the use of hardwired smoke detectors is also acceptable. That's kind of implied, I guess, but as far as the battery ones are concerned, I just wanted to clarify things because of the amount of misinformation that was out there from the media. And from, believe it or not, fire departments were misciting the law as well. So now you know that it doesn't apply to transfers or leases. However, nothing prohibits you as a licensee from recommending to a seller, your client, that they replace the smoke detectors with the new ones, right? As a marketing ploy, right? We have the new smoke detectors in the house. They're not the old ones. They're not 9-volt batteries. So while a seller doesn't have to replace them, you can recommend that they do as a marketing point, okay? And that's not going to expose anyone to liability. The last point I made is that according to a number of reliable sources, the sensors in a smoke detector are effective for a maximum of 10 years. Any smoke detector that's more than 10 years old, throw it away. Go buy a new one. The battery may be replaced, you can press the button and it beeps, but the sensors are no longer operable. So if there is a fire or there's carbon monoxide, it's not going to go off because the sensors are bad, or the sensors may be bad. Okay? Also, did you know the more times the smoke detector goes off, the less sensitive the sensors are? So if you have a mother like mine who burned food my entire childhood, it was a joke. That's how we knew the food was done. The fire alarm went off. You know, that alarm is not as sensitive as it would have been had it not been for all those burned roasts and things like that. So I wish I was kidding, but I'm not. So new smoke detector law. That probably takes a lot of stress out of people. Janita's coming over. Hold on.
Pam Jones, Hudson Gateway. Do you have a citation for the law, a place where we can go and actually look at it in case there's some confusion in the offices about what an agent's responsibility is, if any?
Agent has no responsibility.
Okay. Is there a citation, though? Do you have
I
a
don't have it specifically, no.
Okay.
But you can Google it. It's not, I mean, it's there.
Okay, so it was passed and signed into law?
In
The
2015.
the amendment was?
The
Yes.
amended date was in 2016, yes.
Okay, all right, so we'll just have to look it up. Thank you.
Janet Bashir, Greater Capital Association.
Don't know you.
Don't know you either.
Janet's a frequent flyer in the hotline, so.
Sadly, but true. So, what if a home doesn't have a smoke detector and it's going to need one? Would you still allow them to buy the ones that are in stock at Home Depot?
So they are selling these sealed battery units now. It's not like on April 1st they're going to change out their inventory. Most places already have these 10-year sealed batteries, so they're out there. And if they don't have a smoke detector, charge them more commission. Because if they don't know enough about smoke detectors, they probably, no, but you should honestly, I've had a few members contact me about this and they ask me, well, Anthony, can I just buy a case of these and put them in my trunk? And when I have a listing, I just give new ones to the homeowner and they just swap them out. And yes, you could, if you wanted to, have a listing, replace the smoke detectors on your own dime if you want to. Okay?
Hi, Christine Jones, Dutchess County Association. Is it likely that a local municipality can be more restrictive and require that under your multi-families perhaps, landlords management might have to have them replaced?
Municipalities can make more restrictive rules, bless you, George, than the state has, yes. But you'd have to check your local laws for that. Okay?
Does this also apply to carbon monoxide detectors?
No, only applies to smoke detectors.
And you mentioned the 10-year lifespan on the sensors. Is that for the wired ones as well, or just battery operated?
That's all sensors as far as I'm aware. I think they put the same sensors in regardless of what it is, just the power supply that's different on them.
Thank you.
Yep. Okay. Hey, guess what? We have a new protected class in New York State. Executive Law Section 292. Effective in 13 days? Kind of. Kind of effective in 13 days. Gender identity or expression means a person's actual or perceived. Okay, that's what's going to get us in trouble. Not actual or perceived, and I'll mention why. Gender-related identity, appearance, behavior, expression, or other gender-related characteristic, regardless of the sex assigned to that person at birth, including but not limited to the status of being transgender. I think it's a very all-encompassing definition. It's not leaving anything to the imagination. They're saying what they're saying. Why do I say kind of? Because back in 2016, the governor passed a regulation found in 9 NYSAR, section 466.13, adding gender identity as a protected class under the human rights law. How the governor did that is he expanded the definition of sex, right, sex, male or female, to include gender identity. Now, was this the proper way to do it? No, it was not, but it was the governor's fix to an issue that he wanted to get resolved. Normally, you would do this statutorily. You wouldn't do it regulatorily to change the definition of a word within a statute, but the governor did that back in 2016. And the regulation included gender identity under the definition of sex. There's the new definition versus the old definition. They're not that different. They cover the same set of individuals. So we've had this in place since 2016, which is why I said it's kind of new. Also, being realtors, we've also recognized gender identity for years before the state did, so we should be practicing this anyway, pursuant to the Code of Ethics. And I have perceived in red because the person doesn't have to have a gender identity issue. If you think they do and you treat them different because of it, then you are liable under the human rights law. Even if Fred isn't transgender, but I think that he is because of his little doohickey in the back of his head, I can be held liable for just thinking that he's transgender and treating him differently. So he doesn't have to be transgender. The person does not have to be transgender or have gender identity or expression issues. It's how you perceive them. And that's the important thing, right? The way someone talks, the way they dress, the way they do their hair, that has nothing to do with the services we provide to them. And they codified this in the executive law. Of course, Article 10 had it since 2014, gender identity. So we understand that, again, as realtors, we've recognized this well before the state of New York did, which is something that as a group of individuals we should be very proud of, that we took the step before the government did to protect these individuals. So, again, the areas of the executive law that cover us, this is the one about real estate brokers, about availability of property, et cetera, and they added in gender identity or expression as a protected class, and there's many other sections. It also includes vacant land and commercial space, not just residential transactions, so all property is covered by this as well. And again, the same thing here, gender identity expression and housing accommodations. This is the area of law talking about printing or circulating advertisements for property. If you indicate in some way that it's not available for people with gender identity or expression issues, then that's a violation of New York State human rights law. Okay? I think that's a simple one. Okay. The National Association of Realtors, on the first of the year, had a new addition to the Code of Ethics, Standard of Practice 1-7. The part in red is the part we're paying attention to today. Upon the written request of a cooperating broker who submits an offer to the listing broker shall provide a written affirmation to the cooperating broker stating that the offer has been submitted to the seller landlord, or a written notification that the seller landlord has waived the obligation to have the offer presented. I'm a cooperating broker. I give the listing broker a piece of paper that says, please verify the fact that you gave my offer to the seller. Okay? You affirm. There's a difference. Affirm is a strong word in legal community. Okay? Affirm is almost like you're swearing, and not swearing with F-bombs, swearing, you know, this kind of swearing. So there is no NAR or NYSAR standardized form. However, this morning at the statewide forms committee meeting, we discussed drafting a statewide version, so that will be coming down the pipeline soon. LIBOR has a very good form they've provided us to look at, so we'll probably be taking a look at that as well and incorporating as much of that as we can. There's no required language, and it can be simple or as complex as you want to make it. Okay, it can be very simple. It can be 3 sentences, as long as you get the point across about what's expected. Licensees that provide the affirmation must be truthful, right? Because now your license and your licensure can be affected by whether or not you fill out this form truthfully. Affirmation may be used against the licensee if dishonest. DOS will be able to use the affirmation against a dishonest licensee in an administrative court hearing. It's also a breach of fiduciary duty to the seller if you don't submit the offer but you swear that you did. Also, possible issues of self-dealing if you don't submit another broker's offer but your offer in-house was accepted by the seller. That's kind of self-dealing because the Department of State believes that you're doing so to promote yourself more so than helping your client or acting in the best interest of your client.
Why don't they just have the seller sign it? And then there should be no equivocation.
Because the National Association of Realtors cannot compel a seller to do anything. Sellers aren't members. You can't make a seller sign something. Okay, we're a volunteer organization. They're not members. They don't have to abide by our rules. So the licensee would sign it, thereby exposing themselves to liability if they're untruthful.
Hi, Robin Tristinelli with the Dutchess County Association of Realtors. My thought is just that if they're going to not present the offer to their seller, what makes me think that they're going to tell the truth by signing that form?
Because if they sign the form fraudulently, then they're putting their license up for grabs by the Department of State. Because not only are you not being honest and trustworthy, but you're also not providing full range fiduciary duties to your client, and you're swearing to it on a piece of paper. Right? What more proof do you need? I think that's the deterrent, is that now there's something historically that's going to be there that they can go back to and say, well, wait, you never submitted it. but here's something saying that you did rather than a conversation you had with them. Okay?
Thank you.
Sure. No, we had the microphone.
I really didn't need this, but is it only upon request from the other broker?
It's
or
only
agent?
upon request.
Thank you.
Well, you give them the form, right? Here's the form, fill it out, right? The cooperating broker provides the form to the listing broker. Listing broker's not going to have their own form because they don't have to. Mr. Lance.
There's no requirement, or there's no prohibition with a seller signing it, though, if an agent asks the seller.
There's
sign
nothing
it.
prohibiting the seller from doing so, no.
And it doesn't have to be a piece of paper, right? It could be an email or a text message.
I think that electronic communications would suffice as well.
Thank you.
If the listing agent has a seller that says something that you put up there, like no offers will be submitted to the seller below, if the seller requests something specific and you send in a request that your offer has been presented, does a listing agent have to provide what was in writing by the seller to say my seller does not want to look at any offers under $400,000 or not?
They should provide you with something stating these are the seller's limitations upon what they're going to accept. Okay?
Thank you.
So long as they are lawful. Obviously. You'd be surprised. Okay. So we just answered the question for this whole slide. We can skip this one. DOS opinion about escrow account charges. This is an interesting one. This is very recent. Last week I got this opinion from the Department of State. So I had a broker call me up and say, Anthony, I have an escrow account I'm opening, but my bank is going to charge me a fee if I have less than $500 in that account. And they're going to take the fee out of the account every month, which, right, they can't do because it's an escrow account. You have to, monitor the money, et cetera. So what do you do if this happens? So the general business law requires that all contracts where there's an escrow down payment must be in the contract telling you where the bank is and where the down payment is going to be deposited during the term of the escrow. Again, 175.1 talks about your obligations as a licensee to maintain an escrow account separate from your normal account and not to commingle monies in your escrow account, which is, we're kind of talking about commingling here a little bit because if they take fees out, you got to put the fee back in, and it gets kind of messy. If you forget to put the fee in every month and your account goes negative, then the department can come after you for that. So I think this is somewhat problematic for brokers who don't want to every month check the balance of their account to make sure that it's not going to go over or have an overdraft issue. So I requested an opinion from the Department of State. If an FDIC insured account has a minimum balance requirement, may the broker deposit an amount equal to the minimum balance so as not to pay a monthly fee. I thought that was reasonable question. And the department has said that's fine. That would not constitute a commingling violation provided the account balance never falls below the minimum threshold requirement so that the broker's clients were then funding the account to avoid the maintenance fees. You have a bank tells you $500 minimum balance. A broker is permitted at the onset to put that $500 into the account and they never touch it again until they close the account. That's permissible. So long as the ledger you have for that account shows deposit one, broker funds $500. And then going forward, you keep a proper ledger of what goes in and out of that account, but that $500 never leaves. Even if you can't pay your electric bill that month, you can't take any money out of that account to pay your electric bill. The money has to stay there. Straight behind you.
Anthony, my bank where I have two escrow accounts charges a $2 a month fee, no matter what the balance is, for sending you a statement.
Then I think you could probably fund that on a yearly basis. Again, denoting in your ledger that $24 to cover $2 monthly charges for the account. But you don't want that $2 taken out of your client's money ever. So you want to front load that account and then do it accordingly. I know it seems like a very minor issue, but it's not, because people called up and asked questions about it. So I don't want to see brokers getting in trouble for having an account like this and having the bank take money that's really the client's money instead of the broker's money. So it is permissible, again, just by front loading that account with the amount. The department said if a broker does this, they want to maintain a detailed ledger to make sure that no client funds are being used and that a complete rendering of the account is possible. If a broker is concerned about compliance with the opinion, again, deposit an amount equal to the minimum balance due and leave the money in there until such time as circumstances change. Either the bank stops charging a monthly fee, or you change banks, or you go out of business. Okay? Any questions about this? I think it's pretty straightforward, but again, important. So it's tough to find a bank that doesn't charge fees anymore. I have my account with Key Bank, which I nicknamed Fee Bank, only because of the fees. But I guess other banks do the same things I found out when I changed. So, okay, Liz. Everyone, Liz Salone is going to be giving a presentation on paying for reviews, likes, and ratings.
Can everyone hear me? Okay, hi everyone. Talked to a lot of you probably on the hotline. So this is something we've been asked about a lot lately, and we discussed it with the Department of State, and their views basically were the same as ours, so we thought we'd do a presentation on it. This is paying for reviews, likes, and ratings. Okay, so NYSAR best practice. Down. Twice. And then. Okay, so here we go. I thought that was the wrong one. So, can I pay for reviews, likes, or ratings? This is not specifically addressed under the New York State license law. Article 12A does require that advertisements cannot be dishonest or misleading. So, Real Property Law Section 441-C, I kind of call this the catch-all because a lot of times people will ask me, you know, well, this is not a specific violation, but the DOS does have pretty broad discretion under here to reprimand bad behavior, sanction it. So if you look at it, it says if such licensee has been guilty of fraud or fraudulent practices or dishonest or misleading advertising or has demonstrated untrustworthiness or incompetency to act as a real estate broker or salesperson, as the case may be. So we highlighted dishonest or misleading advertising, and that's where this would fall under. But the DOS has also indicated if you're not disclosing certain things with, trying to get reviews or likes, then that could be considered to be untrustworthy behavior. So we'll get into that a little more now. DOS authority, besides 441-C, they use this case, which says, accordingly, the secretary must be accorded broad discretion in imposing penalties designed to safeguard the public interest and discourage real estate brokers from engaging in shadowy practices. So, it falls under our code of ethics as well. Realtors shall be honest and truthful in their real estate communications and shall present a true picture in their advertising, marketing, and other representations. So not directly referenced, but it falls under that. And then... I didn't know that was there. Interesting. I didn't know that was there. I wasn't expecting that. So, therefore, client reviews that are placed on any website used by the licensee for advertising purposes should reflect the true opinions of the client and not be guided by the licensee. So you don't want to be saying, tell them that I did a good job. You want to just say, what did you think of my work? If, give me a review. Reviews should be based on the actual experiences and opinions of the reviewer. Real estate licensees should disclose whatever reviews were received in exchange for anything of monetary value. So if you're asking your clients to review, give me a review and I'll give you a $50 gift card to Amazon or, Cheesecake Factory, whatever, that should be disclosed. It's more likely that the reviewer will be influenced by receipt or knowledge of the payment. So generally, even if they didn't have a wonderful opinion of the transaction or whatever, they may be more likely to say something nice because they're getting a gift at the end. I know I would feel guilty giving a bad review if somebody's giving me a gift. So that's the issue here. The other thing is that another curtain. So therefore, potential clients may also be likely to hire licensees who have a larger number of reviews. So if you're paying people to give you reviews, and then that could affect business as well, because somebody might look and say, well, this guy has 200 reviews on here, and this guy has 2. Obviously, I want to go with the guy with more experience. So you want to disclose, that so that they have an accurate idea that some of the reviews were compensated. Licensees should ask clients to disclose in the review that they were paid in exchange for an honest review. So if you're posting it on a public website like Facebook or something, you would say, please write, I was compensated for an honest review, something like that. Or like there's an example on Amazon. Sometimes if you're not a verified reviewer, they'll have you write that. At least this is what I've been told. I have a few author friends, but they say that you can say I was given a free copy of the book in exchange for an honest review. So something similar to that, to saying that you were compensated for your honest review. They want to say honest, so it doesn't look like they were swayed. Or by licensee commenting that the reviewer was compensated for posting their honest review. So if you're using it on your own website, for example, you would disclose that. Payment must not be conditional upon licensee receiving a positive review. So even if somebody gives you a 1-star review, if you told them, I'm going to pay you for your honest review, you give them the gift card, the money, whatever, no matter what. DOS discipline, we already looked at 441-C. This is just a reiteration. If a licensee failed to disclose that the review was posted in exchange for compensation, or they directed what the client said in a review, they may face sanctions by the DOS under Real Property Law 441-C for misleading advertising, also, untrustworthy behavior. But wait, there's more. This falls under the FTC as well. The Federal Trade Commission also has laws about paying for likes, reviews, etc. What is the FTC? Protecting consumers and competition by preventing anti-competitive, deceptive, and unfair business practices through law enforcement, advocacy, and education without unduly burdening legitimate business activity. That's the dry quote. And then under FTC 16 CFR Part 255, it talks about what an endorsement includes, then it talks about under D, it includes any product, service, company, or industry. So right here, we're just showing you that, licensed activities, real estate licensed activities would fall under this. And then under this part of the 16 CFR Part 255.1, endorsements must reflect the honest opinions, findings, beliefs, or experience of the endorser. Furthermore, an endorsement may not convey an express or implied representation that would be deceptive if made directly by the advertiser. So this is actually more specific than the license law, but this governs it as well. This is actually stating that you have to give the honest opinion of the consumer. Can I ask for a review? Yes, you can. Advertisers can request that clients or customers write reviews for them to use in their advertising, but the review must reflect the true opinions and experiences of the client and or customer. Can a licensee pay for online reviews under FTC rules? You can again, but disclosure of material connections. When there exists a connection between the endorser and the seller, licensee of the advertised product, that might materially affect the weight or credibility of the endorsement, i.e. the connection is not reasonably expected by the audience. Such connection must be fully disclosed. Again, this is due to the fact that it's going to potentially sway what the person is saying about your service. So what else does this impact? Under FTC rules, if a positive review is used in advertising, it must be disclosed in reviews. If the reviewer was paid for said review, as it is possible that the reviewer's favorable opinion, what I just said, was influenced by the payment they received. If you've given these customers a reason to expect a benefit from providing their thoughts about their product, you should disclose that fact in your ads. Also applicable, New York State General Business Law 349, deceptive acts or practices in the conduct of any business, trade, or commerce in the furnishing of any service in the state are hereby declared unlawful. Should be noted, also, some websites discourage or may even prohibit asking clients or customers for reviews. For example, Yelp states the following, and this is just literally a copy and pasted disclaimer from Yelp. They discourage this. So you would want to check the terms of the website to see if, asking for reviews violates that, because different websites will have different opinions on whether you can ask for clients to give you reviews or not. And here are some examples. So one of them, and this is pretty common, like broker's page on Facebook or like post on Facebook or Twitter, and you will be entered into a raffle to win a gift card. This is technically paying for likes and should be disclosed. So it's obviously disclosed right on the post that this is a contest if you like it, but if in another post you might be quoting like, I have this many likes, for example, that would be something you'd want to disclose because you technically gave monetary value for the likes. So quoting positive review from client on your own business webpage when the review was paid for. So this is on your own page. If you put in quotes, so-and-so was the best. This is the best real estate transaction I've ever had. They were so wonderful. Must be disclosed on your website that review was paid for. You would have to put that yourself. And then some more examples, paying clients to put reviews on a third-party website, such as a social media page. This is where since you can't put it in yourself, somebody else is putting it in, it's not your own website, you're not typing it yourself, you should request that the client put language in the review indicating that they were paid for an honest review. This is like the example I was saying with Amazon, where people say, I was given a free copy of the book for my honest review to avoid the review not being posted because it's not a verified purchase. So that's kind of like similar, but not the same. But and then another example, give me a positive review and I'll discount my services next time you use me. Can't do it. Obviously, you can't give incentive for a positive review, only for an honest review. We've said this a million times, but that reflects the true opinions and experiences of the client, and with disclosure of incentive. And also, incentive includes anything of value or potential value to the consumer. So it could be being entered into a raffle, getting a gift card, getting cash or money through PayPal, even getting discounts on future services. That is, so if you say, I'll give you, if you use me next time in your closing, I'll give you $500 cash back at closing and a commission refund. That's an incentive. So anything of value. And then also, please review my services on my X website if you have time. So my page on Facebook, whatever. If this is allowable, you don't need to disclose your request review. So if the client received no benefit from providing such review. However, you cannot request that the review be positive or direct what the review says. So you don't have to disclose you asked for a review if there was no monetary value given for the review. So if it was just, please give me a review if you have the time, I'd appreciate it. That's fine. Don't have to disclose it. As long as you're not saying, the only thing that wouldn't be allowed is saying what, you please say good things about me. So any questions?
Can you counter negative reviews?
You mean like on the website specifically?
On the website specifically? If someone gives you a negative review, can you counter those?
That depends on the website. Yeah, that would depend on the website's terms. So some websites, would allow it and some wouldn't. If the website allows it, you could. But, generally, you'd want to remain polite, obviously, and that sort of thing. But, yeah, it would depend on the terms of the website.
So if you ask for a review, like the bottom section on the last slide, and then afterwards you send a thank you gift, like a $10 Starbucks card, do you have to go back in and say that they were compensated?
You would, right, because you don't have any...
If it wasn't they're not being incentivized.
Yeah, so only if the reviewer knew or should have known. So if they have, at the time they're writing the review, they have no reason to believe they're going to be compensated. If you don't say anything about it and it's just a pleasant surprise, and yeah, that wouldn't need to be disclosed because their review wasn't swayed in any way by, thinking they're going to get something out of it. So known or should have known. So if you gave them no indication or where they reasonably should have known, then that wouldn't need to be disclosed.
Yeah.
What about running an ad to get Facebook likes? Like I'm running an ad for a page I paid money for those likes on that page. Does that have to be disclosed?
That would, right? If you're
So you run a Facebook ad to get people to like your business page. Facebook is, but you're paying for the likes. Well, yeah, that's okay.
Facebook's paying them, or
Facebook's not
No.
paying the people making the likes. He's paying Facebook.
oh yeah,
That's fine.
Pam Jones from Hudson Gateway. I'd like to go back to your example of the raffle.
okay, sure.
I'm going to give you a hypothetical. I have a $50 gift card. This month, there were 5 clients that had the opportunity that if they gave a review, they could get the gift card. Through the raffle, 1 person got it, 4 people did not get it. Is that considered an expectation of something?
Yes, because they still have the chance to win it. So
That's what I just wanted
Yeah.
you to clarify, that
Yeah.
the opportunity to
To
have
win,
the
right.
chance to win.
that would be
is the
considered something of value,
compensation.
right?
That's what I wanted you to clarify.
Right, right.
Over here. Okay. Tony Crystal, Hudson Gateway, right here. Oh, I do? Oh, okay. Okay. Question about where the disclosure. Is there any specific size for this disclosure? And can it be on your Facebook profile page? And can it be just located somewhere on your website in a small, is there a size for the print?
So no size, but it has to be readable. It can't be like, you don't want to do like anything with fine print. Yeah, clear and conspicuous. Okay, so clear and conspicuous in close proximity from where the review is. That's from Anthony. So there's not a specific size requirement, but yeah, it has to be clearly able to be seen and clearly to where the review is, so you can see that what it's referring to. So something vague like just I may pay for review likes wouldn't be sufficient. You know, if it has to be where you're, it has to be clear what you're getting compensating people for.
Quick question here. Miguel Berger from Greater Capital. Now, if I hire a company, let's say a marketing company, to go and get likes on my page, so I'm basically compensating, I don't know if they're compensating somebody, but I'm compensating the company, so potentially they can be compensating people to like the page.
Yeah, that would need to be disclosed because people are going to look at how many likes you have, and if they were swayed by people getting paid, then yeah, that should be disclosed. Any more questions? Yes, no.
If you're putting up only the positive responses, are you also obligated to put up the negative ones?
Yeah, you have to put. Yeah, you would have to put it up.
So if you put up only positive ones and don't put up the negative ones, is that okay? And the answer is no.
No.
That's misleading.
Right.
I'd love to do that, believe me.
On the prior question, where you paid an ad agency or someone to put an advertisement, which includes the choice of the viewer to either like or not like, you're indicating that that's payment, but that's payment to a third party for doing an advertisement. How is that run?
Because Miguel said the third party may be compensating the reviewers also.
Oh, if the third party is reviewing okay, got it.
Okay? Okay. Next topic. NAR Code of Ethics and... I was going to thank her at the end, but that's okay. We can make her head grow a little bit bigger during the middle of this thing. But very good job, Liz. Thank you. Should also mention that Liz is also with child. So number 2 is on the way. Due in June. Correct. So compensation from home inspectors. So what can a home inspector pay you for? Can a licensed home inspector pay a real estate broker for referrals of inspections, either current or future? Being included on a list of recommended home inspectors? Being labeled a preferred provider? Or anything similar to, oh, that should be 2 and 3 above, not 3 and 4 above. And the answer is for all of them, no, they cannot. 19 NYSAR section 197-4.7. Home inspectors shall not directly or indirectly compensate in any way real estate brokers, salespersons, real estate brokerage companies, etc., for future referrals of inspections or for inclusion on a list of recommended inspectors or preferred providers or any similar arrangement. That's pretty black and white as far as I'm concerned. We get these calls on the hotline all the time. The home inspector wants to pay me to be put on my list. Well, according to this, they can't pay you. Brokers and their associated licensees should not accept anything of monetary value from home inspector if it is given for the purpose of current or future referrals or inclusion on a list of inspectors preferred or recommended. Okay? Again, what can a home inspector pay you for? Legitimate advertising open to any other licensed home inspector. There's no exclusivity. If you have a page of providers and they want to pay anyone who can pay to put on it, that's fine. They're not preferred providers, right? They're paying for advertising space. That's different. Licensees should not be directed to use a licensed home inspector that advertises with the brokerage. So they are permitted to advertise, but the broker can't say, licensees, you have to use ABC home inspectors because you're paying us $1,000 a month to have their ad on our website. You can't do that, right? That's quid pro quo kind of stuff. If they don't compensate you directly or indirectly, there's no issue. If you want to have a list of providers on your website and you don't make them pay at all for them, if they practice in your area, you'll put their name up on the list, that's okay, right? It's not a preferred list. It's just a list of providers. And you let the consumer make the decision who they want to retain for a home inspector. But if there's any kind of transfer, any kind of monetary incentive for you to recommend them or put them on the list, then it would be prohibited pursuant to the code rules and regulations. Any question about that? That's pretty straightforward, right? Oh.
So I have my list, but I have a couple of home inspectors that I really don't like. So I don't want to put them on, and they come to me and say, I want to be on your list. I said, no.
They're all licensed. They're licensed just like we are. They perform the same service. So again, I think that would be you're showing your preferred inspectors compared to just a basic list. Rick?
Anthony, the home inspectors are coming by the office all the time. With candy? Not the ones that come to our office. With candy. But they do bring brochures and flyers with them. And oftentimes those brochures or flyers have some kind of discount coupon attached. Now, it's no benefit to the licensee, but is there any issue with that?
Again, so long as you comply or they're complying with the regulation itself and it's not being done in a quid pro quo kind of way, and you're also providing names of all the other home inspectors in addition to this one, and I don't see an issue.
Okay.
Yeah, that's...
Thank you. As a local board, we may have home inspectors as affiliate members. And as a local board, we probably will push our affiliate members on maybe our website or an agent's day or what have you. How would this affect a local board?
Local board's not a broker.
So no effect?
Okay. Wow. NAR Code of Ethics and Accepted Offers. Standard of Practice 1-15. Realtors in response to inquiries from buyers or cooperating brokers shall, with the seller's approval, disclose the existence of offers on the property. Standard of practice 3-6, realtors shall disclose the existence of accepted offers, including offers with unresolved contingencies to any broker seeking cooperation. These are two different things. One is saying just offers, one is talking about accepted offers. Standard of practice 1-15 versus 3-6. Difference between the two is that offer versus accepted offer. Right? Standard of practice 1-15 requires the seller's consent before you can disclose any offer on the property. Seller's consent. Offers are submitted but not yet accepted by the seller. Offers are non-binding and may be done in any form. It could be a letter of intent, memorandum of understanding, a binder, an unsigned purchase contract. Those are just offers. There's no binding effect to any of them. They're just an offer. So they have no legal standing technically until they are accepted offers, which we will talk about. 3-6 requires disclosure of accepted offers regardless of what the seller directs. The consent of the seller is not required when you're disclosing an accepted offer. Accepted offer has different meanings to some in different practices. Technically, some people call an accepted offer a verbal acceptance. Well, in New York State, all contracts for the transfer of real property must be done in writing. Verbal acceptance doesn't mean anything. It's a promise. I made my parents a lot of promises growing up. I didn't keep any of them. It's just a promise, right? It's an agreement to agree. That's not a binding contract. Written acceptance, however, is. Right? Written is binding, if it's a contract that was signed. So as far as we are concerned, in the Realtor Association, accepted offer has only one meaning as it applies to Standard of Practice 3-6. So we had an email communication with NAR back in 2017 about this, and in their response, they gave the definition from Black's Law Dictionary about what an offer is. And what NAR is saying that when we speak about offers within the code or NAR policy, they mean a purchase offer that a buyer is presenting to a seller for the sale of real property that has not yet been accepted by the seller. That's just an offer. An offer is an offer. And then obviously, you don't have to disclose offers unless the seller gave you permission to do it. No matter what the other broker says, you're being unethical, you have to do this. No, you don't. Unless the seller tells you you can. Okay? As compared to an accepted offer is a purchase offer that has been accepted by the seller, thereby forming a purchase contract between the buyer and the seller. Something that's binding. In that case, you have to disclose. Even if the seller tells you no, you have to disclose. DUS agrees with that as well. You have to be honest and trustworthy with all parties involved, and that includes disclosing the fact that there's an accepted offer on the property, because then the next buyer is technically second in line, right? So they can't get that property unless offer number one goes away. And at the end, we'll do questions. So the timing when an offer is valid or when it's accepted would be legal determinations and are fact specific. Again, taking into effect the statute of frauds that requires those writings or those contracts to be in writing. Verbal offers in New York State are not enforced. So I added to NAR's response about what New York law calls an accepted offer. And again, in New York State, it's one where a document that can bind the parties to the sale is executed by both parties, either with a wet signature or electronically, okay? I do not believe you should be charged with determining if there is a possible binding oral agreement or some other remote exception to the statute of frauds. It's not your job to think about, oh, maybe this is a contract because I read an article once where if you put a bunch of emails together and that makes terms of a contract, it is. That's not your job. So unless you have that signed contract, right, either wet signature or done electronically, then you don't deem it to be a binding offer. If a seller has verbally accepted an offer or was presented with a writing that would not be binding when signed, there's no accepted offer. I think the joke we had 10 years ago was binders aren't binding. I still seen some of them. Some of them are binding, some of them are not. But if it's a non-binding document, then it is not an accepted offer pursuant to the Code of Ethics. Therefore, a seller may direct their listing broker not to disclose any offers that were made on the property. Again, however, the listing broker must disclose that the offer was accepted, regardless of what the seller or seller's attorney tells you. Now, let's back up a little bit. Realtors shall disclose the existence of accepted offers, including offers with unresolved contingencies. An attorney approval clause is an unresolved contingency. It's still a binding contract until the attorney waives it or declines that contract. So don't use the excuse that it's in the attorney approval period, therefore it's not an accepted offer. It's an accepted offer. Attorney approval is just another contingency, like inspections, like mortgage contingency. It's the same thing. That's a contingency. There's an accepted offer, right? Yeah. All right, we have Lori and then Mike. Someone.
Okay. In the upper part of New York, you do contracts. In the lower Hudson Valley section, we do non-binding binders. And we have promoted within our own association that once there is an accepted offer, one where a buyer is now proceeding to inspection and then eventually to contract, which would be binding, that during that time period, in order to be fair to cooperating brokers, they should be aware of what is going on. In Jersey, they call it ARIP. We don't have a status. But what you're saying is that there are no accepted offers until contract is drawn, which is a solid 2 weeks sometimes from the time the seller gave his word to accept.
If you go farther down south, it's more than 2 weeks.
I can go all the way.
Sometimes.
But under the Code of Ethics, and this is one of the codes that I teach when I teach ethics, the concept of accepted offers, just those words, would be the action that a consumer took, a seller took, saying, yes, I accept your offer, even though it is not memorialized in a written contract. It becomes kind of difficult if you're saying that our accepted offers are not accepted offers until, they're not binding till contract, but you're not acknowledging acceptance of it. So I have a little problem with this.
This is NAR's definition, Lori. It's black and white.
I need help from you from NYSAR because I still have a problem. NAR is a country.
No, Lori, we've discussed this with NAR. The issue is it's got to be binding. You have to sign contract, or else it's not an accepted offer pursuant to the standard of practice.
So we cannot charge agents from not disclosing if they're not in contract.
Correct. As long as the seller told them not to disclose.
But Anthony, once they're in contract, they're in contract.
They're not in contract till they sign a contract, Lori.
Well, in our area, yeah, okay, thank you.
Catherine DeClerc, Hudson Gateway. So by that explanation, then there would never be an accepted offer because it would go from the existence of an offer directly to contract.
And they're calling a contract an accepted offer.
So from the consumer's standpoint, which I think is what everyone should be concerned about, is that it's misleading to the consumer who thinks it's a property is available and there are no accepted offers. Then they go to make an offer and they find out that there was an accepted offer, and the first buyers move through to inspections and what have you. So it's deceptive to the consumer to say that those binders are not accepted offers when they are.
But they're not pursuant to NAR's definition. That's my point. You don't have to disclose those offers unless there's a signed contract. If the seller tells you not to, that's it.
Hi, question just as a follow-up to that. Kathleen Breen from Sullivan County Board of Realtors. So you've interchanged between contract and binder. So here we use the binder, the offer to purchase. We have the buyer signed it. It spells out their contingencies. If we have that flip page, the second page, that then has the seller sign acceptance of that binder, does that constitute accepted offer? You have two signatures.
If the terms of the binder would constitute a contract under the law, then it would. You'd have to examine each binder to see whether or not it contains the elements of a contract for real property.
So that would take into effect, rather than waiting the 2 weeks and everything like that, if that would then
Well, that's
shorten
that's
the
the
process.
non-binding binder versus the binding binder.
Right. That's what I'm. Gotcha. But that just because you mentioned about the
No, I'm
binding
not-
binder
I
and the
mean, it's funny,
non-binding
but yeah,
binder.
that's the
and that's the
non-binding-
binding binder, is that there be 2 signatures on that binder,
Not necessarily, because the terms may not be.
so long as they meet the requirements for a
Correct,
contract. Correct.
yes.
That's what I'm saying to you. But that would also then prevent that 2-week, month-long, well, in Sullivan County, it might be 4-week long before a contract was done by an attorney.
Mike?
Clarify for us in writing signature. So obviously we have a lot of folks using binders. So the agent working with the buyer sits with them and has the binder signed. And in many cases, they're emailed, faxed, so on and so forth. And the agent, the listing agent has instructions that everything is to go through them. So they speak with the seller, and the seller accepts the offer, meets price and terms, but they're not going to sign that binder under their attorney's instructions. So now you have an accepted offer signed by the buyer, seller giving you instructions to proceed forward, send the binder to their attorney for a contract to be drawn. Where are you in that?
You have an unaccepted offer.
That is what I'm trying to get to, and that's what I wanted to hear you say. I'm hearing something in the background asking you to say that again.
There's a whole bunch of people. Hey, buddy.
Rich Haggerty, Hudson Gateway. It's my understanding, I'm not sure if Linda Page is in the room, but there are only 2 entities. There are only 2 entities that can determine what violates the Code of Ethics: NAR and the hearing panel.
Correct.
So it seems to me that if NAR is taking a position, they need to have a case interpretation that clarifies that position. And I'm not, Linda, correct me if I'm wrong, I can't recall a case interpretation that deals with this issue. So I understand you're saying that this is NAR's position, but if it's really going to have a binding effect on how the code is interpreted, it's got to be a case interpretation.
Okay. So when's the Professional Standards Committee meeting? I'm not kidding. So whoever's on that, maybe we could bring this up and ask for New York to ask NAR for a case interpretation on it? Okay.
Hi, Anthony. Harding Mason, Hudson Gateway. Same topic. In the lower part of the state, we have a situation where you're getting accepted offers verbalized between the agents and the buyer and the seller, and everybody's saying, yes, we're going to go forward. And there are other people wanting to make offers or not waste their time. And there seems to be a groundswell that the agents would like to know, is there an accepted offer, unwritten, no contract yet, but are you going to waste my time going when there's someone already going to inspections and going all the way through the process? And according to what you said, you're saying don't tell them anything.
As long as the seller tells you not to, correct, unless there's a binding offer.
So in under the concept of fairness, which what we've been talking about for the Code of Ethics, the other agents want to know. They want to know fairly. Do you
So I
have
wanna
an
know a lot
offer
of
on
things,
this
too.
property? Sorry?
It doesn't mean you have to tell them. I mean, they say you don't have to tell them unless the seller tells you to. It's black and white. It's black and white.
You know, what are you going to tell your seller? Please don't tell me to tell to the other agents that there's an accepted offer. You know,
I really don't see the issue. It's black and white. It's black and white.
Now, there's more here to this. It may be black and white where you've got attorney-prepared contracts and you've got binding binders and what have you, but that's not what's going on in the real world. And other agents want to be treated fairly, and that's what we're teaching brand new realtors. Treat people fairly. We even have people that would like to get that information put into the remarks in the MLS. Yes, I have an accepted offer. That's one thing that's going on. Other people are calling and say, oh, I'm checking on this property, 123 Main Street. Is it available?
It is available.
Or does it have an accepted offer?
And you don't have to disclose that unless it's a binding offer.
Okay. Peter Caruso, LIBOR. On this whole topic, the problem is NAR is not protecting the consumer. Let's go down the road that he's talking about. Very simply, the owner says, I can instruct. So someone calls from XYZ Realty, I say there's an acceptable offer on the home. Engineer set for tomorrow, we are still showing. We're doing everything right. There's an acceptable offer. It's verbal because we won't let sellers sign binders because it only binds the seller, not binds the buyer. So very simple, we need to get purchase offer contracts here. But before we even get that far, that's what we all need to be doing, we need NAR to protect the consumer because we all look like a bunch of idiots when we tell the consumer it is available. When the owner verbally accepted an offer, which is acceptable, it's pending going to contract. At that point, we do still present the offers because we have to by law, but a lot of times in good faith, the sellers will stick with the first one. Sometimes they'll switch, but the point is it affects all of us when someone calls our office and we say, yeah, it's available, and when you get there and spend your whole Saturday and go there, oh no, it's already, engineer was done this morning. This isn't right. We need to address this on a higher level, or we need to do purchase offer contracts across the board.
Hi. Can you send everybody an email advising what the elements of a contract are?
I will not be doing that, no.
Maybe a class?
It's not your place to determine whether or not something is a contract or not. That's outside the scope of your licensure. Okay, we're going to go on to the next topic.
Oh, it's Anthony. Oh, Anthony?
Yes.
I have one quick question. Sorry.
Where's
over here?
Mike.
So somebody puts a binder, they sign the binder, the buyer writes an escrow check, we deposit the escrow check into our account. Now the signature isn't fully, the binder is not fully signed by both parties, but now you have that money that's been deposited. What happens then?
That money has no effect on whether or not the contract is binding.
Okay.
And I'll just go quick, Anthony. Kevin Otherman from LIBOR. Anthony, this is very simple to me. I have a lot of sellers, and of course I get the difficult ones. And, all right, no, seriously. I just had a seller find 3 offers agreeable. We don't use the term accepted offer or anything else like that. They're agreeable, move forward, do the inspection, 3 different inspections scheduled. And if a seller wants to roll that way and they want to be a very shrewd negotiator, and that's the way they want to play ball, you have to follow their legal advice. So the property's available, that's it. And if people don't like it, then as Peter Caruso said, we have to start doing purchase offer contracts, period. That's the only solution. But to say something is protected, and for those of you in the room who think that you want to drink the Kool-Aid and say this is accepted, then have your seller sign something that's binding. That'll solve your problem if that's the way you want to practice.
Okay, we're moving on to the next topic. Okay. New sexual harassment laws and the employment of assistants. Why am I talking about this again? This is my 3rd time talking about it. Because I can't tell you how many phone calls I received about the new sexual harassment law and who is covered by it and who doesn't. And the most problematic scenario is hiring personal assistants. So the new sexual harassment law and personal assistants, many licensees and teams hire personal assistants, okay, because they need assistance, no pun intended, with their day-to-day activities as far as being a licensee is concerned. Now, pursuant to law, the personal assistant must be an employee. They cannot fit the definition of an independent contractor. They have to be an employee, paid by the hour or paid a salary. They're W-2 employees. The employer is responsible for the payroll deductions, right? So you got to get workers' comp insurance, Social Security, all that stuff. The employer pays a portion of those particular fees and taxes and whatnot. I don't care what you call them. If you hire them, they are a personal assistant. You can give them a fancy name if you want, but they're still a personal assistant as far as we are concerned with this presentation, okay? But what if they are a licensed personal assistant? Here comes my aneurysm starting to flare up a little bit with this. Probably every other call about this issue is about licensed personal assistants, which is how pervasive this unacceptable practice is within the state of New York. There is no such thing as a licensed personal assistant. They don't exist. Does the Department of State give you a license that says licensed personal assistant on it? Then there's no such thing. Personal assistants cannot be a licensee and act as a licensee. If they choose to be a personal assistant, they are choosing to act as a non-licensee. If they want to act as a licensee, they're an associate broker, or a salesperson. They're not a licensed personal assistant. Only a real estate broker may pay a licensee performing a licensed activity, not the team or licensee hiring that licensed personal assistant. If they're performing a licensed activity, they are a salesperson, associate broker, can only be compensated by the broker. A team or licensee is prohibited from compensating an assistant that happens to be licensed for performing a licensed activity. So we have teams and licensees hiring personal assistants who happen to be licensed, and they're paying them to do licensed activities. They're paying them to show houses. They're paying them to cold call. They're paying them to market. Those are all licensed activities. You know who can pay you for that? Only your broker. That's where the problem lies. Happens all over the place. An employer or personal assistant must comply with the new sexual harassment law, provide compliant sexual harassment policy to personal assistants, as well as providing compliant sexual harassment training to personal assistants. Which means if you're a broker and you permit your licensees or teams to hire personal assistants, you better make sure they're providing the training. They have these policies in place because there's an issue. Brokers should be prepared for employees of a licensee or team that furthers the broker's business to be considered an employee of the brokerage if brought before the Department of Labor or Workers' Compensation Board. The state of New York will find the deepest pocket they can. Chances are it's the broker, not the licensee or the team leader. Okay? So that's who they are going to go after because the personal assistant was acting in a capacity to further the broker's license. It's the broker's business. In such cases, the broker's office sexual harassment policy would be effective. Brokers should have a strong personal assistant policy in place, and you should consult with your counsel about what this policy should say. If you're going to permit your teams and licensees to hire someone as an employee, you should have the guidelines by which they can do so. Now, I would recommend, and people don't like this, but that the broker be the employer. And that solves all your problems right off the bat. Your licensing team instructs you how to pay that personal assistant. It can't be contingent upon a successful transaction, but the broker would be the employer. Broker would provide the training, broker would provide the policy, and they make sure that those payroll deductions are taken out, that the licensee or team is not treating this person as an independent contractor, which is misclassification. It's very problematic. There's a lot of potential for liability with this. It hasn't happened yet, but it will happen. Somewhere down the road, it's going to happen. Some personal assistant's going to get hurt. They're going to get hurt on the job. They're going to fall, break their leg. They're going to try to make a claim. And then this is all going to hit the you-know-what, and it'll be an application to the NYSAR Legal Action Committee. But these things happen. I think we had, what was that case down where the unemployment board found that the licensee was actually an employee, and then we fought that. That was down in your neck of the woods, wasn't it? 10 or 12 years ago? No? 15 when Mike was around? Oh, okay. I could be mistaken, so. Was it in Rochester? Okay. But yeah, I mean, listen, the state will try to find the deepest pocket. Deepest pocket's the broker, right? It really is. So they will find a way to make the broker liable. That's how the state works as far as departments are concerned, not so much as far as courts are concerned. And again, consult your own counsel when drafting a policy as far as allowing your associated licensees or teams to hire a personal assistant. Effective July 11, 2018, sexual harassment policies prohibits confidentiality or non-disclosure agreements and settlements as far as sexual harassment is concerned. Prohibits mandatory arbitration of sexual harassment claims. I mentioned before, this may not survive the Federal Arbitration Act, but at this point, it's law. Effective October 9th, requires the training to be in place, requires the policy to be in place. The state has provided samples for all of this. If you follow the state sample, you're in compliance. NYSAR took the state's policy, cut and pasted it, inserted NYSAR where it says insert employer's name here, and we just added one provision pursuant to NAR's instructions about what happens if the CEO is the individual who's being complained of as far as sexual harassment is concerned. That's the only thing we changed, which made it stricter, not less harsh. You have to do interactive training as far as sexual harassment is concerned. The training must be offered on a yearly basis at a minimum and must be completed by October 9th, 2019. These are all the different things the policy has to have on it. Again, we've talked about this at the last legal update, and these slides are available for your viewing after the legal update is over. NYSAR, during the real estate services meeting tomorrow, will be considering an affinity partner that provides online training that is compliant. Barbara, I know your hand's up. You can dislocate your shoulder. Well, remember in school, like it's up too long, you like take your other hand behind and try to hold it up, and it's tiring. Just so you know, the company that we are looking at tomorrow is the same company NYSAR has decided to utilize for our in-house training. So if this is approved tomorrow, you get an announcement from NYSAR about this entity that provides online training that is compliant with New York State training. And what they do is they charge a flat fee for the year based on the number of employees you have. It's relatively inexpensive. If you have like 20 employees or less, it's only like $15 a month. So I mean, it's really inexpensive. But again, if we approve that tomorrow, you'll get a notification of it. And you just sit there and have your employees watch it for an hour. Then the company emails you a completion certificate to show that the person took the course. So it's a very easy solution to this issue. Barbara.
That was my question, but you just said something that I think is not correct, which is you just have them sit there for an hour. My understanding that it's interactive, and I've done CLEs online, which means I need to sit there, my own little computer, and respond, interact, and it wouldn't cover everyone. So like right now, my plan is with employees, they have to be at a separate computer, and that may be a great service, but I don't think you can put them all in one room watching the video. I don't think we're allowed to do that, from what I was told. They have to interact.
My interpretation of the law is different than yours. I believe that would be permissible. It's already been asked of the Department of Labor and Human Services, considering whether online classes are permissible, and they said yes, they are.
Okay, that wasn't the legal advice I got. I didn't come up with that conclusion.
I asked the
Okay.
department who's responsible for it with the state, and they said that they're permissible. Online training is permissible.
With just everybody in one room looking.
Sure.
Okay, I'm going to hold you to that. Thank you.
Hold on. Then one more. Then
I have a question about virtual assistants. How does that play with this?
So are you hiring an individual? Wait, quiet. Are you hiring an individual somewhere else that's acting as your assistant?
You could be hiring somebody who lives in Georgia and you never see them face to face. But
There's no requirement. If they are an employee, if you're hiring the individual and they're an employee, then this would apply.
Only
If you're hiring an entity that acts as a personal assistant and you're paying the entity, then you would not.
Okay.
Okay? Because personal assistants don't have to live in New York, right? Because they're not licensed. They can live in Timbuktu.
myself as an employee, I hire 3 secretaries. Okay? I have to go through training. The secretary is obligated to go through training. I have 32 real estate agents, hypothetically. Okay? Do I have to make them go through the training because they interact with the receptionists, secretaries, whatever you want to call them, also.
So-
and they're independent contractors.
So no, you don't have to provide the training to independent contractors, but independent contractors are now subject to your sexual harassment policy. So if you know or should have known that your independent contractors are sexually harassing someone, you have to do something about it now.
I have to act on it.
But you don't have to provide the training to them, no.
Okay.
Independent contractors are not required to get the training done. Okay, before we go, apparently during the local board forum, is that what was in here right before I was in here? There may have been some discussions concerning individuals who are leaving licensees not feeling very comfortable interacting with them. So you got a creepy guy in your area, okay, who's calling realtors, calling licensees. You know, can I put out a warning about Mr. McCreepystein calling up all my licensees? And here's the issue. The answer is presumptively no, until that individual has been reported to the authorities and something was found that this individual went too far and broke the law. Otherwise, you're subjecting yourself to liability for falsely accusing someone of a crime that they never committed. Just because someone's creepy doesn't mean that they're a criminal, right? Some people are just creepy. Now, what you can do, so I got a lot of calls from local boards about this. Well, what can we do because this person's out there doing A, B, C, D, and E? Well, have they been reported yet? Well, no, they have not. Well, then you can't do anything except to send out a very general kind of educational piece saying, be aware of the following. That piece should not be so specific as to identify the person, right? Be careful of a guy wearing blue jeans, red flannel shirt with a, whatever hat on. That might be a little bit too specific, but beware of the following practices that may be occurring in your area, right? Keep safety in mind. Don't go to showings at 9:30 at night in the middle of a rural area by yourself, right? Those types, I mean, honestly, and it seems very simple, but you don't want to do anything that identifies the individual unless you have some type of record with the authorities where there is some disposition as to the alleged action of that person. You can get in a lot of trouble if you put something out there falsely and it turns out that it's unfounded and this person's just a little bit weird. Right? Well, I mean, come on. We all know people that kind of, they make your skin crawl. You don't want to be around them, but they haven't broken any laws. Right? They're just creepy people. So one, keep safety in mind, right? If there's a reason to be concerned and you think the person's doing something wrong, contact the authorities. Let them deal with it. If you don't have either of those happening, you can't identify the person. You can't warn people about what this person is doing because they haven't done anything wrong yet, technically. Okay, last but not least, 2 minutes, I promise. Hey now. This morning, the statewide forms committee met and discussed the statewide purchase contract. The first draft is done. It's been delivered to all the AEs and EOs and local board council for review. We asked them for input and feedback on the form. Once we receive all that back, we will then evaluate what was sent back to us, make amendments as needed. Okay, we're open to anything, right? The members of the statewide form committee have put a lot of effort into this document. Endless hours. Our goal is to get you a statewide purchase contract before Memorial Day. That's our goal. Just so you know, oh, sorry, that's from me. Thank you, everyone. And that's the draft contract. It's 4 pages and then a signature page right now. It could change. It may not. We don't know. But I just want to let you know we're working on it. It's completed as far as the draft is concerned. Quiet. Hush up. The louder you are, the longer I'm going to take. And I'm between you and the booze again, so. Couple questions? Yeah. Go ahead. You guys want to fight? Are we looking for approval from the Bar Association or the legislature? The answer is no, we don't have to. As long as it complies with Duncan and Hill and has the attorney approval clause in it, then we're fine with it. We don't need approval from anybody else. Yeah, yep. So our goal is to have the form cover the entire state. We understand there's no such thing as a one-size-fits-all form. The practice of real estate changes not just by county lines, but by town lines in New York State. So we understand that if local boards and MLSs want to adopt this, they may have their own local addenda that's attached to it. The document was drafted in such a way to permit this activity so that you can take local considerations into account with the contract itself, but still have the same boilerplate language be on all the different contracts. And we understand some boards won't adopt it, and that's fine. You're not going to hurt our feelings. It's, you know, the membership asked for a statewide purchase contract. We're going to deliver the best one we can. And then if you want to adopt it, you may, but you don't have to. All your AEs and EOs have a copy of it now, as well as your local board council. So how the board decides to distribute that to its members, it's whatever committees they have or procedures, whatever. But it's a draft, so it's still rough. We still got to reorganize it. But all that we need to have in the contract is there, and it's very simple. So be on the lookout for that around Memorial Day. We're hoping to have it completed by Memorial Day. I'm available on zip forms. 2, spring is here in 2 days. Pitchers and catchers report in 2 days. Thank you, everyone.